Hello, everyone. Welcome to our webinar, Suppressing Speech, the Trump Administration's Escalating Attacks on the First Amendment. I'm Chris Oppie, Director of the Ellsberg Initiative for Peace and Democracy at the University of Massachusetts Amherst, where I'm also a professor of history. I'm delighted that the Ellsberg Initiative is hosting this event along with the Freedom of the Press Foundation. I want to begin by thanking the Chancellor's Community Democracy and Dialogue Initiative for funding this webinar. That initiative was created to promote dialogue, academic inquiry, and respect for difference in addressing challenging topics, forms of engagement central to higher education and a thriving democracy. Tonight's event is part of a series of webinars this spring that focus on current threats to fundamental constitutional and democratic rights. You can find details about past and future programs on our website, including recordings of prior events. So please check it out at eipad.org. We'll put a link to that website in the chat. I do want to mention briefly a few upcoming events. On April 7th at 7 p.m., we'll have a webinar called Targeting the University, Censorship, Political Power, and the Fight for Academic Freedom. That'll be moderated by UMass journalism professor Kathy Ford. On April 14th at UMass in the Old Chapel at 4 p.m., we're hosting Be Seriously Scared, an interactive program that combines performance art, historical storytelling, and documentary film to confront the dangers of nuclear weapons and to explore pathways toward nuclear abolition. Tonight's event will be moderated by Lauren Harper. Lauren is Freedom of the Press Foundation's first Daniel Ellsberg Chair on Government Secrecy, a position established to honor and continue the legendary whistleblower's fight for secrecy reform. Her work highlights how excessive government secrecy prevents the public from meaningfully participating in self-government in every area that secrecy permeates, from healthcare, public health to foreign policy. She advocates for common sense improvements to the classification system, reforms to the Freedom of Information Act, and increased government accountability. Harper previously served as the public policy director for the National Security Archive in Washington, D.C., helping researchers get historically significant government documents declassified. Nora Benavidez is a civil rights and free speech expert and serves as senior counsel at the nonprofit media policy organization Free Press, where she manages the team that engages in policy reform, litigation, and community organizing efforts to protect the First Amendment. She has appeared at the White House, the US Congress, the Federal Trade Commission, Canadian House of Commons, and other regulatory bodies to advise on election disinformation, protest rights, privacy and surveillance, and press freedom. Benavidez has authored several original research reports, including most recently Chokehold, Donald Trump's War on Free Speech and the Need for Systematic Resistance. Her articles have appeared in the New York Times, The Atlantic, CNN, and Rolling Stone. Jameel Jaffer is the inaugural director of the Knight First Amendment Institute at Columbia University, which defends the freedoms of speech and the press through strategic litigation, research, and public education. He previously served in various leadership positions at the American Civil Liberties Union. He has argued human rights and civil liberties cases in multiple appeals courts, as well as the US Supreme Court, and he has testified many times before US Congress. His recent writings have been published in the New York Times, the New York Review of Books, and the Guardian. Ben Wizner is a deputy legal director at the ACLU and director of its Center for Democracy, which encompasses the organization's work on free speech, privacy, immigrants' rights, voting rights, human rights, and national security. Prior to assuming this role, Ben was the director of the ACLU's Speech, Privacy, and Technology Project. In more than 2 decades at the ACLU, Ben has litigated cases involving the right to protest, freedom of expression online, government surveillance practices, airport security policies, targeted killing, and torture. Since July of 2013, he has been the principal legal advisor to NSA whistleblower Edward Snowden. So with that, I will turn it over to Lauren Harper. Thank you all.
Thank you very much for that introduction, Chris, and thank you to the Ellsberg Initiative for hosting this great panel that is so in keeping with Dan Ellsberg's legacy. I think tonight's discussion could not come at a more important time. Across the board, we're seeing increasing attempts to criminalize reporting and whistleblowing. We are experiencing perhaps the most dangerous environment in our lifetime for reporting on immigration agencies, especially while being a non-citizen journalist. And we're seeing media conglomerates with business before a partisan Federal Communications Commission capitulate to government censorship, which is all to say, I think we have a really ambitious agenda in front of us tonight. And I'm so delighted to be joined by some of the country's top experts on the First Amendment to talk about all of these issues. Now, before getting into specific topics, what I thought would be really helpful is to start with a scene setting question and to ask all of you to place this moment vis-a-vis the First Amendment in a bit of historical context. So this first question is for everyone. What is the single biggest threat to the First Amendment in 2026, and how does this moment compare to previous eras? I know that's a big one. Answer it however you see fit. Nora, perhaps we could start with you.
Well, Lauren, thank you. You give us the hardest question, and the first speaker. It's great to be here with everyone. It's an honor. I think that these are difficult and tenuous conversations, and I'm excited for the next 90 minutes or so that ensue. I think it comes as no surprise if you know my own work and the work that we do at Free Press that I think the greatest threat we see now is an administration that is retaliatory and emotional and erratic, imposing a range of wildly inappropriate, often not very shocking, but also deeply censorial penalties on anyone and any sector that dares to disagree with it. And so I think that's an easy, clean answer. But I want to layer on top of that one other concern I have about this environment we're in, which is, yes, we see daily, headlines and a barrage of retaliatory censorial actions that this administration takes. We've seen throughout US history examples when the US government has made efforts to censor people's expression and association. And I think in this current, very fragmented reality, one of the greatest concerns I have is what I hear from communities I talk to all the time, which is that the potential silence that we impose on ourselves today or tomorrow might immunize us then from future and erratic, relentless attacks by this administration. And so I think that just to like complicate the conversation from go, yes, we have this administration that has just relentlessly targeted dissent and vulnerable communities, weakening institutions from media to tech to law firms. We'll get into that, I know. But there's just this other like real on the ground element I don't want to lose from the beginning, which is how people worry about and engage in a calculus that maybe they won't speak today or tomorrow and that their silence might save them. And so I hope throughout our discussion we get into questions about what solidarity means, what community work means. I know we'll talk a little bit about that. So that's my short answer.
That's great. Thank you. Jameel, how about you?
Well, okay, so first, thanks, Lauren, and thanks to the Ellsberg Initiative. Um, I feel like Nora has already, answered this question better than I could, so I'm not going to try to go over the same ground. But I do think that the Trump administration poses a kind of threat that we have not had to deal with in this country in modern American history. I think the closest analog is to the first Red Scare during and right after the First World War, when thousands of people were prosecuted for anti-war speech and hundreds were deported on that basis. But in some ways, I actually think this is worse, and it's worse because the Trump administration is going after not just dissent, but going after democratic institutions as well, trying to weaken the institutions that are most important to democracy. So I would, include on that list the press, universities, the legal bar. These are the kinds of institutions that were meant to and can serve as meaningful checks on government power. And President Trump has very effectively gone after them and weakened them considerably already. The one thing that's changed over the last 100 years is we now have a real First Amendment. In during the first Red Scare, we didn't. In fact, the modern First Amendment emerged in response to the abuses of the first Red Scare. So this is a real test of the First Amendment that was created in response to those abuses 100 years ago. The First Amendment was envisioned to be a kind of anti-authoritarian, a check on authoritarian impulses. And we're seeing now, I'm sure we're going to talk more about this, but we're seeing now the ways in which the First Amendment is effective and the ways in which it's not.
Ben, how about you?
Well, there's no wrong answers here and no shortage of right ones. I think because Nora and Jameel were so comprehensive, I can speak about something a little bit more specific. And that's the effect of Trump's practices and policies on anyone who is not a US citizen. I think that they made a mistake. I think it was actually an error when they arrested Mahmoud Khalil in his building lobby. I don't think they realized he had a green card. When they did realize that he had a green card, they moved forward with great enthusiasm, sending a message to more than 10 million other people who are in this country, not just lawfully, but permanently, that if they engage in speech that the administration considers contra to its foreign policy, they can be rendered to a private prison in Louisiana, separated from their family, and removed from the country. I've been going around telling everybody not to be chilled, to be in the streets, to be loud. But I can't say that in good faith to people who don't have U.S. passports, who are not U.S. citizens, because we don't know how those cases are going to play out. Now, the ACLU and Jameel's group have had some real successes in court. We've gotten many people released from custody through habeas corpus. We've won good injunctions from lower courts. But as long as this remains sort of unresolved and still in litigation, we have an enormous part of our society and a really critical part of our society that cannot participate fully.
Absolutely. And that gets to our first substantive topic, which is immigration. And you answered some of the questions that I had. But, for the sake of our audience, one of the top stories this week is the arrival of ICE agents at airports across the country. This, of course, builds on a year of ever more militant immigration enforcement, often at the expense of our civil liberties. So I want to continue what Ben was talking about and really dig into this discussion about the challenges of reporting on immigration agencies and some of the issues that have come up, particularly with filming ICE and immigration officials. So, Nora, maybe this question is a good one for you. Why is the government increasingly using immigration enforcement as a tool of press retaliation? And what does this mean for the safety of reporters, particularly those covering beats like the border or who may not be a U.S. citizen?
Well, I love that you begin here because it's breaking news and it's sometimes a good entry point for people who are like, why do I care about free speech, to think about the news of the day? ICE entering airports is, first of all, just not to help with security lines or efficiency for travelers. I think it is part of a larger effort by the federal government to normalize police presence so that whether it's in plain clothes or in military gear, the visuals of police presence pretty much everywhere become something that people don't question. And that has some ties, as Steve Bannon has promised, for their test runs in the lead up to the midterms. But to your more specific question about press, I'm glad Ben opened this up to and really mentioned that it isn't just journalists and immigrant journalists that are now being targeted. It is a much wider threat that the administration is using immigrants as test cases for rarely used or novel legal arguments that they hope to erode constitutional frameworks. And some of those that have come under attack have been immigrant journalists. An individual that I knew and I worked very closely on the case for was Mario Guevara. He is a journalist from El Salvador Guevara, who was targeted. He was arrested and then detained for 111 days in Georgia, having filmed a No Kings rally in the Atlanta area in June. And he was ultimately then deported back to El Salvador. Throughout the legal process, the government repeatedly said in its findings that it targeted Guevara for his journalistic activities, covering ICE and law enforcement. And he had a very long track record, actually, of exposing and being sort of the first guy on the scene, usually literally just with his phone, streaming what ICE was doing in a given rural or suburban town in Georgia. And he was often then the only Spanish-speaking journalist that provided insights for communities that really didn't go to mainstream media. His deportation really was a quite chilling, I would say almost like tip of the spear, showing us how far the government hopes to go. And as Ben mentioned, there's the Mahmoud Khalil case. There are other student cases that we are seeing, Badr Khansuri, Mohsen Madawi, Rumeysa Ozturk. These are all various people who have engaged in political speech, and the others here have been doing tremendous work that I cite to regularly to fight for their political speech rights. And I think they're really winning. But this is an ongoing threat. And I think I'll just sort of close by naming that I see this emerging tension that the administration seeks to go after immigrants and have two competing areas in our courts. One is in district courts about whether these individuals have constitutional rights at all. And then the second is in what are called immigration courts. Many question the authority that those courts actually have. And those questions that play out in immigration court are about whether the person can be or should be and will be deported. And I see these emerging kind of tensions between the two courts and the judges that are essentially speaking back and forth to each other about, well, you go first. No, you go first. And as that plays out, I think we are getting, higher appellate rulings that question the presumptive authority between these various judges and administrative proceedings. And so I worry where we're headed. And I think these are the kinds of conversations that help then spotlight for us that we can have, tremendous conversation about the legal arguments that might be brought in court, and that ultimately the people really affected and harmed will be those that might move to another country, might altogether abandon coverage for communities at risk or people who don't speak English. Those that are honestly at the most vulnerable point with the least resources are becoming those most under attack.
Can I pick up on a part of your question? You asked about how citizens or people filming police has become sort of a flashpoint, or filming ICE agents. And I think that's really important. I think that's a very important arena here. Because, of course, we see the contrast between federal agents who are masking themselves and filming protesters, and then when protesters pick up their camera to film them back, they're being targeted for that. So this is already being litigated. Now, to be clear, there is a First Amendment right to film law enforcement in the exercise of their duties, as long as you're not actually physically interfering with them doing their jobs. And so we're going to see a lot more litigation of this right. But I really do think that it's central. I think what Trump is frustrated by is that historically policing in the United States is local. There's no federal police force. He doesn't control most of the people with guns around the country. So this surging of National Guard and ICE resources into places is a way for him to have his own agents who he controls, dressed in stormtrooper gear, to try to chill protest, and to see people out in Los Angeles, Minneapolis, Charlotte, in the streets defying it is immensely frustrating to them, and it's a goal to take away our ability to do surveillance on what the government is doing. It's been an extremely powerful tool. People holding up cell phones, I think, have already changed the course of this administration, and probably modern history, and I hope will continue to do so.
That's such an excellent point. And of course, one of the issues with this administration in particular is that, right, a lot of the justifications it offers for ICE agents wearing masks or needing extra layers of secrecy because they're being terrorized by the public is they are giving these excuses and statistics in bad faith. So it's really, really difficult to counter an agency that says we need extra layers of secrecy for our agents, but at the same time, we're going to make it much more chaotic and difficult for you to film our ICE agents and try and get some accountability that way. But Ben, I was wondering if we could talk a little bit more about how we go about protecting the right to record ICE and other immigration agents in public when the DOJ is now filing hate crime charges against journalists who document these protests, when you have ICE agents telling people, hey, we've got a nice little domestic terrorism database that we're going to put you in for exercising these protected rights. So how do we continue to protect this right to record in the face of such daunting intimidation
Well, I mean,
tactics?
be careful about asking a lawyer a question like that, because I'm going to say we are going to use litigation as a primary tool, and I think it is very important. So it is an issue in multiple ongoing cases. We represent journalists and others in Minneapolis in a case that involves the right to record. There will be a new case filed in some state soon that will raise this issue much, much more directly. There's a lot of case law that protects it. It's very hard to protect people from governments that systematically disregard binding case law. So when you do a know your rights training these days, you kind of have to give two versions of it. You say, this is what a government following the law would do, and who knows what's actually going to happen out there. We want to tell you what your rights are and what rights have been recognized by courts, but we can't guarantee that these masked agents in the streets are actually going to respect those rights in those ways. So look, I think that the silly charges that they've been bringing are not going to hold up in court. Their criminal cases have not fared well. Juries haven't liked them very much. Judges haven't liked them very much. But I do think that it's important um, for us to spread the message that people do need to keep using those phones. We do need this record of what's going on out there. We need professional journalists and we need citizen journalists to do it. And the ACLU and other organizations will provide legal backup in situations where that gets people in trouble.
Ben, I think you hit on something important. You guys have been doing these know your rights trainings for many, many years, and it turns out that you need to do know your remedies trainings as well, right? Because um, that turns out to be where things have fallen apart. We're all getting great rulings from district court judges, but the remedies that the courts are able to provide um, aren't fixing the problems. Partly because the remedies are limited, and partly because even the limited remedies are being ignored by the executive. Lauren, can I say one more
Please,
point on that topic?
please.
So, this contrast that Ben drew between ICE agents that are uh, masked and filming ordinary citizens, and ordinary citizens who are being prevented from filming the ICE agents. I feel like that actually captures something really important, a kind of broader point about what's going on right now that I think is kind of crucial to absorb. The First Amendment, when Madison described the First Amendment, he famously said that it was supposed to put the censorial power in the people over the government rather than in the government over the people, right? And the idea is, the government is accountable to us. And I think what you see here is a reversal of that relationship where, the government is suddenly in the position of um, censor, and we, the ordinary people, are in the position of the censored, right? And that is precisely what the First Amendment was supposed to prevent. I think that this comparison of the mass ICE agents and the unmasked, ordinary people is also probably a pretty good summary of what's happened over the last 25 years, even before Trump. The growth of the surveillance state side by side with the growth of government secrecy. You've got the government having more and more power to know what ordinary people are doing. To monitor our expressive activities or associational activities, to intrude into areas that we thought were, private. The government has so much more power, partly because of legal changes, partly because of technological changes. And on the other side, our ability to understand the government, our power to get information from get information from the government has really been curtailed, in so many different ways, and it has definitely accelerated over the last, 15 months. But it did not start 15 months ago. It started long before that.
I'm so glad that you brought up surveillance, especially in the context of DHS, but really across the government. I'm wondering, since you mentioned it, if you or anybody else has any thoughts that they'd like to impart on this expanding role of government surveillance, which has always been a problem, but has really taken off, I would say, in dramatic new directions under this Trump administration, particularly ever since the March 20 of last year executive order on eliminating information silos, which really started to allow agencies, particularly at DHS and ICE, to erode longstanding privacy protections and reportedly allow the Trump administration to start building a centralized national database that would compile the most intimate information on us that could be used as a tool for harassment, whatever you name it. So I wonder if any of you would like to remark on the role of surveillance, particularly as it regards to the First Amendment. Ben, I'd love to start with you, particularly with your
Actually, let's start with Jameel, just because this has been his particular area of expertise, is the intersection of surveillance and free speech rights.
Jameel. Go
Now, now,
ahead.
now I have to figure out something to say. Okay. Well, I think, part of the problem here is that, when we're talking about direct government censorship, we actually have legal tools we can use. Uh, they're not always effective, again, because, mainly because the remedies are so weak, I think. But there are legal tools we can use. We've used them effectively in some of the cases we've already referenced, involving non-citizens. We've, used them effectively in many other contexts as well. With surveillance, I think the legal tools at our disposal are much, much weaker. And that's partly because the Supreme Court doctrine on First Amendment doctrine relating to government surveillance is, basically non-existent. The only doctrine that exists relates to standing, and the rules relating to standing uh, almost foreclose um, constitutional litigation relating to government surveillance. The First Amendment litigation relating to government surveillance. So that's one reason it's really difficult for us to get traction on those kinds of issues. The other is the statutory law is also very weak. It's all of it was written generations ago. The Privacy Act needs to be amended to address the technological changes of the last 30 years. We have infamously no general privacy law in the United States. There are just very few legal tools, and so all of this. All of this surveillance takes place without uh, real legal constraint. And to the extent there are constraints on the government's collection of that information, the government just collects it, then it just buys it instead from the private sector that's not constrained. So it's a terrible system, and there's a kind of desperate need for legal reform here.
Ben, how about you?
Yeah, I mean, I guess I will add here, we don't know what we don't know. My view is that in this area, particularly of secret surveillance programs, we need a very consequential whistleblower at least once a decade. So we're overdue. Um, because that not only tells us things we didn't know, but also creates the necessary disruption and energy that we can actually do something about it. We need the narrative of it as well. Um, I think I have a counterintuitive view here. I mean, I think the Trump administration has been relatively low tech and relatively non-secretive. Again, we don't know what we don't know, but they're doing more things in plain sight and daring people to challenge them than the administrations that I'm used to. They are tweeting the snuff films of their missile strikes in the Caribbean. And So when we bring a lawsuit, are they going to try to invoke state secrets? It would be odd. Maybe they will. Sort of similarly, I think there's a lot of concern. You read the stories about Palantir, but mass deportation is a low-tech operation, high cruelty, low tech. Um, 10 million people can't hide and don't try to hide. They go to school, they go to work, they go to hospitals, they go to courtrooms, they go to their immigration appointments. The reason why we haven't had mass deportation in recent years is because no president wanted it, not because we didn't have Palantir. So I don't want us to get too caught up in a conversation about surveillance technology here when I really think the story is brazen cruelty and lack of accountability.
Nora, do you have anything you'd like to add before moving on to our next section?
I think I would just I want to highlight the local and state element here and the ways that local and state governments are collaborating with private companies. So much of what we do at Free Press is, to analyze and track, monitor how private companies are in bed with the federal government and how they are capitulating to Trump's whims and of course, his directives. I know we'll get into some of how Trump also does that with agencies. But at the local and state level, there are untold relationships between private companies, as Ben alluded with some of these, Palantir, but there's also many others. And that is not new. But on top of the ongoing local relationships that essentially allow warrantless searches and gathering and sales and purchases of information about people in different places, there's also federal fight that is playing out now in Congress. And so I think I'd be remiss if on a conversation about like the urgent threats right now to free speech, I think about what we're seeing playing out when it comes to the Foreign Intelligence Surveillance Act, FISA, and that there is an active debate now as to whether that should be reauthorized. And the White House is playing a key role. Stephen Miller is a leading advocate for reauthorizing Section 702 without reform. That would previously in the past, it's enabled agencies like the NSA and the FBI to conduct millions of warrantless, what are called backdoor searches into emails, texts, calls from people around the US, and particularly including journalists, protesters, and even members of Congress. And so I think if we're like, I imagine that the conversation in part is to explore and debate here and to educate our audience about how the very complex and thorny relationships across private sector, federal government, and then local and state allies to the federal government are playing out. And so I think, ICE in airports is just one visual inflection point for us to see that things are changing, but there is a consistent theme in which those in power, whether they are in the federal government or the owners of private companies that are in bed with government agencies, are really allowing for a winnowing down of access. And I think that's going to play out in the rest of the conversation as we pursue what is this tension between long-standing values we believe or may hold on what free expression and association mean, and then what does it really look like with the government that is hell-bent on pushing the boundaries, in part to distract us and keep us on our back foot and prevent proactive, progressive solidarity building.
Nora, you mentioned educating our audience, so I would actually like to bring up a question that was asked in our Q&A that I think is relevant to this section before moving on. So this is for anybody who would like to take it. But the question is, given the embrace of the use of commercial data by the FBI and the intelligence community, is there a need for increased caution about use of commercial services by rights organizations and journalists? I imagine there are some thoughts here. Would anybody like to take that?
Well, I'm always happy to weigh in.
Please
But
do.
I've gone first several times, so I'm trying to, at least keep it collegial. I don't want to be too robust or comprehensive. Absolutely, there is this could be its own conversation, I think, for the person who asked. The embrace of commercial data by the FBI. I think that's actually just one aspect of the concerns that I have, and I know that my organization would have. But if you take a step back, just today, Meta has been in a jury trial, for example. And one of the findings today was jury damages of upwards of $375 million for misleading users. I think there's sort of a tint that is coloring all of this, and including the question here about the corporate intent and the corporate posture that these entities have, then in bed with organizations or entities like the FBI. So I think there is deep concern, and I would welcome other thoughts from our other panelists, but these are nefarious actors oftentimes, and the profit comes from using and exploiting consumers and users. So just from a baseline, I am always critical about the use of and questioning the use of and the implications of these types of tools.
Lauren, we should probably shout out Freedom of the Press Foundation, where where you are a fellow, because they run one of the best shops for training journalists about how to clean up the tools they use and deploy the right security in all kinds of threatening environments, including threat models that are even more severe than the one that we're facing here in the United States right now. So people who communicate confidential information, that includes journalists, human rights lawyers, and others, have been on notice, at least for the last decade and a half, that they need to up their game. And obviously, what you're seeing with the Trump administration underscores that. But I think that knowledge has been out there in those communities.
Thank you, Ben, and thank you for shouting out Freedom of the Press Foundation and our digital security trainers and Secure Drop. Jameel, do you have anything you'd like to add before we move on?
No.
Okay, well, let's move on to the next issue area that I wanted to talk about, which is basically about access and the government trying to decide, which press outlets have a seat at the table. So, for example, the New York Times just beat the Pentagon in court over a policy that basically would have made investigative reporting illegal. Of course, the Pentagon is trying to fight back with an abridged media policy that is still bad. But I'd like to know from all of your perspectives how big a win you think the New York Times is. And do you think other government agencies will still try to use this same tactic again in the future, or if the Pentagon's going to continue to find ways to evade the meaning of the court's order? Anyone can start us off here.
I mean, I think it's a significant win, and I thought the Times as lawyers did a great job in that in that dispute, and obviously it's ongoing. We don't know how it's gonna it's ultimately going to be resolved, but um, the the dispute about the Pentagon, I think, is representative of a larger class of disputes that share some characteristics, like the exclusion of the AP from the White House press pool is sort of similar. I would say that even during his first term, Trump's blocking of critics from his Twitter account, these are all situations in which there is something that you might characterize as a public forum. I mean, in the terminology of some courts, they actually call it a non-public forum, but the concept is it's like an online version of a town hall or a city council meeting, right? That's the social media, um, public official social media accounts are like online versions of town halls or city council meetings. And these press forums are also, kind of like those sorts of spaces that are opened up to multiple speakers by the government, um, because those spaces become important to our democracy because of the kinds of speech that take place in those spaces. And um, we haven't before had a presidential administration that has excluded speakers from those or excluded reporters from those spaces on the basis of viewpoint. And that actually is a really important and troubling development, not just because like the Associated Press has a right to be in that space or the New York Times has a right to be in that space, but because the exclusion of speakers from those kinds of spaces on the basis of viewpoint sends a message to the speakers who aren't excluded, right? It means that those speakers will hesitate to report as aggressively because of the fear that they might be excluded in the future. And of course, when we're talking about reporters, we're not just worried about their rights narrowly understood. They're there as proxies for the public. And so when they are excluded or they are chilled, it has real implications for, the information we receive about government power. Um, I don't want to overstate the importance of those cases because it's a real question, I think, how much those forums now tell us about government policy and government decision making. It's relatively rare that I, watch an exchange from the White House press pool and I think, wow, I now understand something new about our government. But I think that there's a really important principle at stake here. There are spaces we can debate whether these spaces are the ones, but there are spaces like this that are important to our democracy, and it's important that those spaces be open to speakers or listeners without reference to viewpoint. And if all of those spaces get compromised in the way that the Trump administration is compromising these ones, then that has real, it corrodes the integrity of democratic discourse. It just means that we're getting propaganda rather than information, and that is obviously a real problem, even if you're not sure that the Pentagon press pool is the source of a lot of useful information.
Jameel, at what point does the exclusion of, say, the AP or somebody from the Pentagon press pool cross the line into illegal government censorship?
Yeah, I mean, I think that so it's a complicated question for a reason I'll come back to, but the short answer is if they're excluded on the basis of viewpoint, or if they're excluded for reasons that are unreasonable in relation to the purpose of the forum, the exclusion is unconstitutional. Now, what counts as unreasonable in relation to the purpose of the forum is always contested. Whether an exclusion is viewpoint based is often contested, although the Trump administration often does us a favor and basically admits from the beginning that the whole point of the exclusion was to suppress a particular viewpoint. And I think with the AP, that was obvious. But the reason it's sometimes complicated is that the First Amendment doctrine here, um, uh, says that the government, once it has opened up one of these spaces, can't then exclude speakers on the basis of viewpoint. But it doesn't actually require the government to open up the spaces in the first place, and it doesn't foreclose the government from closing the spaces. And so, the Trump administration can always argue and has argued in the past that it's uh, uh, if it can't exclude a speaker on the basis of viewpoint, it's going to close the forum altogether. And it has effectively tried to do that now with the Pentagon. They've now, just over the last 24 hours, restricted reporters from accessing the Pentagon at all without a military escort. So they've effectively closed the forum. And they will argue in court that the First Amendment doesn't foreclose them from doing that. I think that's a real weakness in First Amendment doctrine, that it doesn't require the government to create certain kinds of public forums. It only requires them outside the context of sidewalks and parks. It doesn't require the government to create public forums. It just forecloses them from excluding people on the basis of viewpoint. So that's a weakness in the doctrine. But despite that weakness, the AP won in the district court. The case is now up on appeal. And the New York Times, as you've mentioned, has won before a district court judge. So I'm optimistic that those cases will come out the right way.
Ben or Nora, would either of you like to weigh in on this topic?
I think Jameel captured pretty well how these cases are sort of simultaneously trivial and consequential. You're fighting over whether you get to ask Pete Hegseth a question in one of his idiotic press conferences. On the other hand, it's not his house. It's not his building. And I don't like seeing um, press events that look like North Korea, where everyone asks sycophantic questions and he answers. It doesn't feel right. It's creepy. I mean, I remember as a kid watching Helen Thomas go at Ronald Reagan, and that's the image that our presidents have to answer, and the reporters are there to ask the people's questions, not their own. And so there is something very real at stake here that is separate from the doctrine, which is, you know, Trump's kind of projection of just ownership of the government that belongs to the people, including the spaces that he occupies.
The only thing Jameel did an excellent job. And Jameel, I want you to teach all of our seminars, on these topics because you always hit the right notes. I guess I think about the proactive measures that I also see the administration taking vis-a-vis quasi press, bringing in far right bloggers to have front row seats and to Ben's, I think, point, asking the questions that will get answers they're excited to give. Concurrent to that as well, the White House has done a few other things. One is to begin its own kind of media website where press releases are issued in the form that they want, and to frame up that the bloggers and the kind of fringe folks that they enjoy coverage by are really covering the White House in the right way. They also have launched a media bias tracker, which is supposed to have this purpose of monitoring what they call fake news. But it's really a kind of hit list of outlets and reporters that are covering Trump in ways that either he or the administration more broadly are hoping to muzzle. It almost feels like a quasi doxing list. And so there's this proactive effort to create news that they enjoy, and that's their prerogative if they want to try to promote a media apparatus. But it has begun to have echoes of other authoritarian regimes around the world, whether it's Turkey or Hungary. We know that a kind of modern strongman will weaken and take hold of independent media institutions. Trump's involvement, for example, in the TikTok deal, which, while it's social media, is still media, and his attempting to, bring in ally and billionaire friends who will buy up various outlets, whether it's the Ellisons or others that help then craft a dominant narrative that he wants. And so from my own research, from the work that we've done on monitoring that corporate capitulation element, I think Jameel's exactly right. Given the legal side here, I think there's just a growing cultural element that people are wrestling with. And so much of that comes out of, or at least has these seeds in Trump's own efforts to embrace lying. And that he almost seems like he can't not lie. And that kind of permeates so much of the ethos that the administration and the press office bring to what is considered official or allowable news coverage.
You brought up such an important point, which I hope we'll have time to talk more about later, which is the corporate capitulation aspect. For the time being, I want to stay a little bit in the national security space. Specifically, we've seen this administration, everyone from the Director of National Intelligence, Tulsi Gabbard, to Attorney General Pam Bondi, call journalists traitors or threats to national security for reporting on leaks of classified material. So I would like to ask point blank, and for the record, do reporters have the right to report on leaked material, even if it's classified? And what kind of chilling effect does this administration's comments have on both the whistleblowers who would leak that information and the reporters who would report on it?
Unfortunately, the point blank answer is it's complicated. We have a long tradition or at least a modern tradition in this country where almost every day of the week you can open up our leading newspapers and read classified information that has been leaked officially or unofficially to our news organizations. Having said that, the Supreme Court has never said that reporters have a First Amendment right to publish the nation's secrets, and it's come close to saying the opposite. In the Pentagon Papers case, the court said that there would be no prior restraints on publication, but the court expressly left open the possibility of criminal statutes being used afterwards if the government deemed that appropriate. Now, we never saw that. By tradition, it's been understood that our secrecy laws apply to people who have security clearances, who are in a privileged relationship with the government. Even there, we didn't really see prosecutions before the 80s and 90s. But it's well established now that leakers to the press, if they work for the security establishment, can face felony charges under the Espionage Act. Until the first Trump administration, we had not seen that directed at a publisher. But as everyone listening here will know, Julian Assange was charged under the Espionage Act and other laws, including just for the act of possessing and publishing classified information. That case was never adjudicated, although there is a guilty plea there. And I have to say, I am a little bit surprised, and this may be speaking too soon, that we haven't already seen the Trump administration building on the precedent that was set then that doesn't necessarily distinguish between those who leaked the information and those who published the information. Now, they can say, and the Department of Justice tried to say that Assange was not an ordinary journalist in the way that he interacted with his source there. But it gets very difficult to distinguish that from the work of, let's say, our most intrepid national security journalists. But I can't give you the answer that maybe you or everyone wants, which is that the First Amendment is a bar to prosecutions in these cases. This turns out to have been a norm. It's still untested. I think there are great arguments that the Espionage Act, which is the principal tool that's used in leak prosecutions, is unconstitutionally vague and overbroad, that this term national defense information that it uses can't mean what it says. But certainly that has not been litigated up to the Supreme Court. And no one listening here is going to be confident that this Supreme Court would get a question like that right.
Lauren, can I?
will, please, yeah.
Well, so two things. Uh, Ben is right, obviously, that the Pentagon Papers case leaves open the possibility of criminal prosecutions. Actually, one FOIA success that we had at the Knight Institute a couple of years ago, we filed a FOIA request for old OLC memos, all old memos of the Office of Legal Counsel, and thanks to the efforts of some of my colleagues, we were able to get hundreds of these old OLC memos that had been, kept secret for many years. And two of the memos were written by OLC in the weeks after the Pentagon Papers decision. And one of them was a memo in which the OLC concluded, this is a memo that went to John Dean, concluded that the First Amendment would not be a bar to the prosecution of the newspapers or the whistleblowers. And they ended up prosecuting the whistleblowers, but they didn't bring charges against the newspapers, but they concluded that they could have. So that's one thing. And then I had a question about maybe it's a question for Ben or Nora if she has an opinion about it. But just curious what you guys think about the Washington Post, the search of the Washington Post reporters, Hannah Nathanson's home and the seizure of her laptop and devices, and whether we should see that search as a kind of first step towards what I also thought would have happened by now already. The indictment of a newspaper or a journalist for the mere publication of classified information.
So I will just say my read of that was that she was not the target of the investigation, but they were trying to figure out who the leaker was. And so the purpose of that was to find out who her source was. It was an overly aggressive tactic that probably violated federal law, and there's hearings about that before federal judges right now. But I didn't read that as her being viewed as either the target or even a conspirator, but rather just that this was their heavy-handed search for evidence of a leaker. But I could be wrong about that.
No, I mean, I read it the same way, but the statute that protects reporters against these kinds of searches, precludes or is supposed to preclude the government from carrying out these searches unless they believe that the reporter herself is engaged in criminal conduct, even if
I
she's not the
think
target, right?
I
You
think
think they
what
just
they
think
said,
they
I think
overlook the statute?
Well, no, what they have now said is that they didn't overlook the statute, but they concluded that because the statute itself also applies to reporters, even if the reporter is not the target of their investigation, the
Mm.
statute doesn't preclude them from that kind of search. And so they're using the Assange case to say, look, um, uh, this reporter was also involved in illegal activity. The fact that we're not going after her is irrelevant here, but
Right.
it allows us to ignore the statute that would have prevented the search.
No,
It's a
no,
little,
no.
probably a little too
I
arcane.
totally agree
Yeah,
with you,
yeah,
but I
yeah.
see that as a terrible sign because The fact that they are willing to say to a judge, we think she is engaged in criminal, she's not the target, but we think she's engaged in criminal activity. Presumably the criminal activity is publishing classified information. And no, they haven't indicted her for it, but they've
I
said
see.
we think we could, right?
We're
I think
making the, I
that's
see.
the message I'm worried about.
I see. Yes. I've never doubted for a second that that was their belief.
Hmm.
I'm glad you
Sorry,
brought up
Mark.
the Hannah Nathanson. No, I actually, I was going to bring it up, and I think it's a great case. I believe the government's arguments are completely hollow and they fall flat. Her reporting focused on exposing what is happening in our federal government. That is a topic of immense public interest. She had, of course, the phone numbers of individuals that obviously were giving her information or would give her updates. And that attack, whether it's through her home or the taking of her journalistic materials, pose, I think, very serious questions. One, from the Privacy Protection Act, but also constitutional ones. And it also, I think, would send a further message to other journalists that might be engaging in coverage similar to expose what's happening in our federal government, raising questions then about the pretext for the FBI's targeting and whether that's actually due to trying to get the sources that she has or some other criminal conduct. But ultimately, I think just sets a chilling tone. And I know that we've
Yeah.
all been working on that case.
I think I answered a little bit too legalistically. And what I wish that I had said, and what I'll say now is that, my whole career, Jameel's career, Nora's too, I mean, has basically been built on unauthorized leaks to the press. Everything we know about the wrongdoing and human rights violations of the last several administrations, we know not because it came out through congressional oversight or through court cases in the first instance, but in the first instance, because it showed up in newspapers, and then we built our cases on top of that. So and this is why, one of the framers was James Jefferson, who said, "I would, rather have newspapers without a government than a government without newspapers." We would have so little oversight and none in the national security space, in the absence of unauthorized leaks to the press. So they're so important. I think where I think it's important for us to recognize the First Amendment arguments are on fairly shaky ground and pretty untested.
I echo everything that has been said during this segment. The other thing that I would just be remiss if I didn't underscore, especially when we're talking about classified information, is that most information the government purports to be classified does not actually deserve protection. Our most accurate guesses for information being overclassified is anywhere between 75 to 90%. But even challenging that, and even challenging if the information is properly classified, but there's a public interest in its release or declassification, is extremely difficult. On this note, I want to talk a little bit about a recent bill that was introduced by Representative Rashida Tlaib. She recently introduced a bill last week, I believe, to fix some of the holes in the Espionage Act, which we've been talking about, and it's called the Daniel Ellsberg Press Freedom and Whistleblower Protection Act. This includes, among other things, allowing the defendant at issue to make a public interest defense. I'd like for you, whoever would like to take this, to talk about why this is so important and perhaps some other things that you would like to see amended with the Espionage Act to prevent it from simply being used as a cudgel against the press and whistleblowers. And I will just add that I am also surprised that we've not seen an Espionage Act charge against journalists. There was a Rolling Stone report last year saying that the Trump administration is eager to charge a journalist under the Espionage Act. So it certainly remains a very real threat, even though we haven't seen it yet.
Yeah, and we did see a letter from some members of Congress about a journalist named Seth Harp, who was the main character on Twitter for a day. He was accused of having doxed one of their favorite words, one of the Special Forces top officers, a name that's very common knowledge and that he had through his reporting and is not classified. That seems to have petered out, but we will see. I don't know, Lauren, whether Representative Tlaib's bill also includes this amendment, which is that the Espionage Act should be amended to make clear that it applies only to the holders of classified information and not to secondary publication, like from journalists.
It does.
Okay, it does. So that I think that's vital to solve the Assange problem, the New York Times problem, the Washington Post problem, and just to say categorically, those people shouldn't be subject to criminal secrecy laws when they're not in that privileged position. You mentioned the public interest defense. Just to give a concrete example. So the Espionage Act makes it a felony, to possess and to disclose national defense information to anyone who's not authorized to receive it. So that would, of course, include publishing it in a newspaper, and that's the complete offense. So when Edward Snowden appeared in the first week of June on the Guardian's website and said, "Hi, I'm the guy who did this," the only question after that under the Espionage Act was what his sentence would be. He had no defense. The offense was complete. It's essentially a strict liability offense. It would not have been relevant had he showed up for trial, that the law changed as a result of his disclosures, that many people in government conceded that some of the information shouldn't have been secret in the first place, that a court, in a case that Jameel was involved in litigating, struck down a policy as illegal, that Congress changed the law. All of this would have been irrelevant and inadmissible in a trial under the Espionage Act. Snowden sharing the information with reporters who won the Pulitzer Prize is indistinguishable under the statute from someone selling the same information to the Chinese military for personal profit. And so what the Tlaib bill says is, we're going to give you an affirmative defense, and we're going to let a jury decide. You're going to get to say, look, first of all, I don't think this should have been classified. This shouldn't have been secret. The public had a right to know. And second, the benefits of the disclosure outweighed any putative harms that the government can assert from the disclosure. The government is very good at claiming harms and very bad at demonstrating them. Perhaps for some valid reasons, but mostly just because they say the same thing every time. And so, Snowden has always said, under that Espionage Act, I would love to have a trial. Under an Espionage Act where the government has to explain why this was withheld, and I get to explain why the public needed it, and bring forward all these witnesses who can talk about the value of the disclosures. I would be happy to face trial, but otherwise, it gives the government complete control over who to prosecute, because we all know there's thousands of leaks a day. The only ones that ever get prosecuted are people who the government considers dissidents, whereas the administration itself and different factions within these administrations leak like sieves to their favorite journalists. So you end up in a worse situation. You have absolutely selective leaks from the administration, which would be worse than total secrecy, because we only get information that serves their narratives. And when there's a strong counter narrative like Snowden, you see felony charges.
Jameel or Nora, do you have any wish list for fixing the Espionage Act, or any final thoughts you'd like to make on the Espionage Act before we move on?
Only that I think the public interest defense is a great idea. I think it makes no sense to categorically criminalize leaks. We need this information, and if you sort of go back over the last 25 years and think about, like, what would we have known about Abu Ghraib had it not been for leaks to the Washington Post, or what would we have known about warrantless wiretapping had it not been for leaks to the New York Times? There are every major development in the war on terror, we understand only because of leaks, and we probably even now have only a partial understanding of our government's policies and the consequences of those policies over those years, because the people who leaked that information to the press did it under threat of many years in prison. If it had been open to government insiders to make information available to the press and then defend their decisions to a court, we would certainly have it's basic law and economics, right? We'd certainly have more information now about the government's policies and what happened because of those policies. So I think that these reforms are way overdue. Many of us had hoped that they would happen in response to Snowden's disclosures, or even before that, in response to some of the disclosures relating to torture and drone strikes. But it would be, it would be great if we could make these happen over the next couple of years.
Yeah, I would just add, these topics that are so critical to the here and now, the government's most contentious and controversial, arguably illegal activities, are extremely difficult to win through methods like FOIA. Jameel, you mentioned the Foundation's FOIA win for those OLC memos. You mentioned they were older OLC memos because that was, I think, in some ways the easiest ones that were available to get. Those were OLC memos dating from the 1970s. Is that correct?
Yeah, that's right. That's right.
Right. Yeah, FOIA is a vital tool, but access to contemporary information is reliant
Yeah.
on leaks.
I did, more recently litigate this case for one of the drone strike memos. And after, like, when I was at the ACLU with some of Ben's now colleagues, we were eventually able to convince the Second Circuit to publish this OLC memo that authorized the CIA and the Defense Department to carry out the targeted killing of an American citizen. But the only reason we won that case for the Second Circuit is that the Second Circuit became persuaded that all of the crucial information in the memo had already been leaked to the press, or not even leaked, but had been made available to the press by the Obama administration. So, that's what counts as a FOIA success these days, is you get the information that you already have.
Nora, do you have any final thoughts on the Espionage Act before we move on to a topic that you mentioned already, corporate capitulation?
Well, I would defer to Jameel and Ben on their long history working on this issue, but my only comment is a procedural one, which is, it's easier to kill or prevent a bad bill from moving often than to push for something meaningful and a reform that we would want. This Congress has held more hearings and passed less laws than almost any other Congress. That's not typically a bad thing, but in this case, I think that the Ellsberg amendments are critical. And so, from just a procedural standpoint, moving these forward and bringing a kind of sense of, a groundswell of support and understanding for why these amendments are critical is one that I know Free Press is supporting. Freedom of the Press Foundation and other organizations that have been working on this for years. So, the evidence of and the fruits of your labor finally coming out, I just applaud.
Thank you. For this next section, there's a lot that I would like to get at, but what I'd like to talk about broadly is what it means to have a blatantly partisan FCC and the impact that that has on free speech. So this first question is general for whoever who'd like to take it, but if you could explain for our audience, what is the role of the FCC and why is it so dangerous under the leadership of someone like Brendan Carr, who I would be remiss if I didn't add sometimes wears a gold Trump lapel pin. So anybody who wants to take it, please.
Nora, you want to take it?
Yeah, I was
Free Press,
unmuting.
Free Press does a lot. Yeah.
That I'm like, I guess this is for me, but Lauren's being elegant. Anyone who wants to take it. So there is so much happening in this space now. The FCC has broad authority over a range of communications methods that people across the country engage in. And that relates to who has broadcast licenses, broadband and internet usage for people around the country. This won't be a history lesson on the FCC, but this particular agency has presented ongoing signs that it seeks to pressure both through coordinated and systemic actions and alignment with the Trump administration, ways to pressure and move media companies. That can and has taken the form of pushing for Disney, ABC, Nexstar, and Sinclair to remove Jimmy Kimmel and his show. FCC Chairman Carr pressured those companies to take action when Trump disliked Kimmel's coverage. This was back in September. But we've also seen more recent news, and it feels, at least from the perch we sit at Free Press, that there is a near daily headline about the ways that the FCC in particular is misusing its authority, seeking to extend its authority outside of the bounds of what it should. For example, what are the censorial, if censorial, practices by social media companies when they engage in content moderation? And so I think there is just such a rich area here. Most recently, we sued the FCC. We filed in the U.S. Court of Appeals for the D.C. Circuit regarding the merger between Nexstar and Tegna, and urged that as the companies consider combining all operations, we are asking that the court set aside the FCC's approval of that deal for now. But whatever action that this commission currently takes, we are seeing it consistently align with a censorial agenda, and one that is predicated on editorial choices that Trump himself often wants the FCC to make, to pull or leverage its heft to force private companies, to make editorial decisions. So I'll leave it there, and I absolutely will talk more about some of the other things we're doing when it comes to corporate capitulation.
So just to give a little more context here, the reason why we have an FCC is that the public airwaves are a limited resource. And, particularly if you think about something like radio, there's not an unlimited number of licenses that can be given out, because there's not an unlimited amount of space for radio to be broadcast. The same with broadcast television. And so the authority that the FCC is exercising here is that the FCC has a mandate to ensure that broadcast licenses are, sort of used in the public interest. Now, the public interest has always been understood to mean something closer to community service. That if you are a local broadcaster, you have to have the needs of your community in mind. It's why you see all these public access shows that, have school board meetings or other community things going on. That's how they're satisfying the public interest. Public interest has never been understood to mean that the director of the FCC can exercise political judgment about whether a news organization that criticizes his party is acting in the public interest. And so he's taking actually the standard that exists and then transposing it into a context where they're using it for real viewpoint-based coercion that's made a lot easier by the authority that Nora just alluded to, which is the authority that the FCC has over things like mergers. And I'll pass it to Jameel because he wrote an op-ed about this for the New York Times.
Well, yeah, I mean, I think that the really interesting and disturbing thing about all this is that these are areas in which the entities that are being attacked, the media institutions, it's also true of the universities and the law firms, but these entities all actually have the law on their side. They have very strong arguments under the First Amendment. And if you look at the cases that were brought by some law firms, or the cases that were brought by the case that was brought by Harvard, you can see that when they sue, they actually they do pretty well. The puzzle is that so many of them aren't suing. Instead, they are effectively surrendering to the Trump administration, giving in to the threats and the intimidation, and then hoping that the coercive campaign will end. And we've seen that is usually not the case. Like with many of the universities that entered into settlements with the Trump administration, only days went by where the Trump administration came back and made additional demands. And the same was true with the media organizations as well. Even CBS, which has really, I think, debased itself in its capitulation to Trump. Even after they installed a political ombudsman, even after they installed Barry Weiss, a Trump approved editor in chief, even after they um, canceled shows that Trump didn't like. Even that it wasn't enough. 10 days later, Trump was unhappy with something that they reported, and threatened them on social media again. So you can't really you can't buy peace with the Trump administration. There's no settlement that sticks. Trump sees these kinds of settlements as just a sign of weakness and a sign that there's more value to be, excavated from the uh, uh, or squeezed out of the institution. But I think that this phenomenon of these elite institutions capitulating to the administration is in some ways the worst aspect of everything that's going on right now. It's um, because I said at the beginning that the First Amendment was sort of meant for a moment like this. It was built for this moment. It was intended to be our preeminent check against authoritarianism, and so now it's being tested. And we have this tool that we didn't have 100 years ago. When the first Red Scare happened, there was no First Amendment. There was no First Amendment doctrine. Now we have not just First Amendment doctrine, but free speech protections that are the envy of citizens of other democracies. The media institutions here have so much more protection than media institutions anywhere else in the world. And yet, when these institutions are confronted with these kinds of threats and intimidation, they just don't assert their rights. They just, fold instead. And that, I think, has been the most dispiriting thing about this whole these last 15 months. I know I've already been speaking for a while, but I just want to say one more thing about this, which is sort of connects to something that Nora said right at the beginning. Um, you see these leaders of elite institutions surrendering to the Trump administration, and I contrast that to these non-citizens who we at the Knight Institute represented in this, challenge to the arrest and threatened deportation of non-citizens who participated in pro-Palestinian protests. These are people who really had something to lose, and yet they came to court and they testified against ICE in open court. And one of them, he's a professor at Harvard, and he was testifying in open court, and he was talking about the chilling effect that the Trump administration's threats had had on him and on his colleagues. And a government lawyer stood up on cross-examination and said to him in this kind of gotcha tone, "Well, if you're so chilled, what are you doing here in open court? If you're so chilled, like, why are you here testifying against ICE?" And, I think the government lawyer, thought that he could just sort of sit down and rest on his papers at that point. But this Harvard professor said, I think that's a really good question. I'll tell you, I thought about it really, really carefully. And I thought, I don't go to protests anymore, but American citizens can go to protests. I don't write letters to the editor anymore, but American citizens can write letters to the editor. The one thing that American citizens can't do, but I can do, is testify about the chilling effect on non-citizens. And he said, "I know all the risks, but I'm a Harvard professor. I have much more protection than anyone else, who shares my immigration status. And I'm here because I care about the democracy that I made my own. I'm here because I care about my kids' future. I'm here because I feel like it's my obligation to be here." And I contrast that with these leaders of the most powerful institutions in the country, who are one after another just surrendering to Trump. And I just don't understand why these people have so much to lose, have so much more courage, than people who are so protected.
Such a beautiful comment. And it leads to one of the two last questions I'm going to ask. For context, we have about 10 minutes left. So I'm going to ask these two questions and then turn it over to our panelists for any final thoughts that they might have. But I think Jameel raises such an excellent point. Nora, maybe this is a good question for you. Why are we seeing billionaires like the Ellisons, who are in the process of major mergers, is seemingly align their editorial content with what the administration wants it to be.
Well, I think there's actually a very simple answer, which is the financing, that it benefits these individuals and the bottom line for these companies to align with those in power. Elon Musk faced the potential SEC investigation, any number of fines that would be levied against his myriad companies in the lead up to the 2024 elections and then what would follow in 2025, and has since been able to cut deals to prevent so much of those investigations from ensuing. Other companies have also just padded their purse strings in aligning with the administration. In the research that we've conducted, one of our kind of hallmarks is the Media Capitulation Index, which analyzes how the top 35 largest media companies have consistently abandoned policies on DEI, have changed their various editorial decisions to calm down or weaken criticism of the administration. Many of them have engaged in settlements. We know that platforms, for example, have settled upwards of $60 million for having removed Trump way back after January 6th, 2021. Whether it's settlements, editorial decisions, policy changes, or even just the quiet abandonment of website pages at these corporate, headquarters and websites, there has been enormous financial gain for them. And I know we're coming up on time, there is one small kernel of hope that to the contrary, consumers do not want that. Costco, for example, is one of the best examples that when it doubled down on DEI measures, its membership actually rose. And I think that consumers here are beginning to wake up to and understand that there is a inherent and troubling power dynamic between a winnowing control regime between the administration and these private entities. And so, as power amasses for a very small group of people, we know that inequality is one of the most dangerous signs of rising authoritarianism, and that kind of unrest also signals future and growing violence. And so I think that's the question, at least that I sit with, is, where do we go from there? Not just for free speech, but for people's awareness that this is the kind of environment that sets the stage for broader muzzling of anything that is seen as even tentatively oppositional to those in power.
I think that's right. I think the Kimmel story is a sign of weakness and a sign of strength. Um, Obviously, we're vulnerable when important news organizations are owned by corporations that are themselves subject to other regulatory pressures. And obviously, the reason why Kimmel was kicked off the air was because the parent company cared much more about some other business interest that would be threatened than it did about Kimmel's show. But when the media is corporate owned and it's answerable to the bottom line, that can cut both ways. Because remember, Kimmel was back on the air in a few days. And the reason why he was back on the air in a few days is that a couple million people cut their Hulu cords. There was a huge public outcry. And I think that the parent company saw its stock price teeter a little bit. And so the people have a move in a system like this. And I think we need to think about how to organize and use that power, having identified this weakness, that our, sort of critical news organizations are subject to these market pressures.
Jameel, would you like to add anything before I ask my last question?
Go for it.
This actually builds on something that you said. You mentioned the bias ombudsman. So, for our listeners, Paramount accepted bias ombudsman. His name is Kenneth Weinstein to get a merger approved. My question, you can answer simple yes or no or elaborate as much as you'd like, is this the start of a trend where the government installs political monitors in private companies?
I mean, there are people like this now installed at private universities too, right? We don't use the same title for them, but they have been installed through these settlements with the Trump administration. Um, so unfortunately I do think that there's a trend here.
I think, well, I agree with Jameel that this is a kind of trend I don't see disappearing. But I also think that there is a kind of chaos that the administration loves to spin up so that we are consistently distracted, the media included. And if we are constantly digesting, analyzing, having to think about, debate, disagree with each other on issues from yesterday or today, we can't then properly challenge whether it's in court, or whether it's the court of public opinion, or in our newsrooms, the consistent rising threats that we've talked about all evening. So I often think there's a mix of sort of organic and coordinated chaos that is spun up by the administration here and by its sort of desire to throw spaghetti at the wall. Sometimes that is brilliant, and other times wholly overestimated. And the problem there is sometimes the overestimating results in people feeling like we can backslide and underestimate. But there's a kind of chaos by design that allows and kind of begins to build up chaos that organically and serendipitously will lead us to say we don't quite know. And that means that for those in the defensive roles, like literally all of us here, there is a kind of vigilance needed. There is also a real people's playbook that is needed to maintain awareness, education, and an ability to engage in our expression and association so that we don't risk losing those rights altogether. If we wake up one day and what we thought was something we could underestimate was in fact deeply problematic, like the ombudsman and other examples.
Well, I will say, I think we've been disappointed in some of our elites, and we've seen that some of the leaders in our society will make decisions that are in their own best interest or their perceived best interest rather than in the public interest. And I think we have to accept that. And the question is, what are we going to do about it? And what we need to do about it is to show them that what is in their best interest is what's in the public interest. We need to change their incentives. We're starting to see that with law firms. The ones that thought that the path of least resistance was to go down to Washington and sign a secret deal with Boris Epstein and Donald Trump have lost their reputation. Some of them have lost businesses. And when Democrats have a House of Congress back, they're going to be called to testify about just what they agreed to. And so maybe they're not going to do the right thing for the right reasons, but I will accept them doing the right thing for the wrong reasons. And similarly, I mean, Harvard's president gets a standing ovation at their commencement, notwithstanding all kinds of things that Harvard has could have done better over the years. And Columbia is a pariah. So I think we all need to, within the networks that we're in, make sure that people just maybe change their calculations. Most people want to be on the winning side. And so it's very important to project that capitulation might have a higher cost than resistance.
We have 3 minutes left, and those were such excellent answers to my final questions, but I would still like to open it up to our panelists for the opportunity to make any final remarks in these last 2.5 minutes. If any of you have any concluding remarks, please, the floor is yours. If not, I would like to say just thank you very much for this wonderful discussion. Truly, it was a privilege to be here with you all tonight. I'd also like to thank our audience for joining us and listening to us tonight. If you'd like to know anything else about the Ellsberg Initiative, please visit their website at www.eipad.org. And for any more information on Freedom of the Press Foundation, please visit freedom.press. Again, thank you to everyone for their time tonight talking about what I think is really the most critical issue facing us today. And thank you to our expert remarks from our panelists. So thank you very much for joining us tonight.
Thank you, Laura.